I'm not going to use again. Then she's going to expect that you're using.
Today's docket call opens with firm courtroom rules. Any gallery contact with inmates means immediate removal. Several cases move through PTD, plea deadline, and discovery status checks. The headline, a murder defendant enters a no contest plea. The court imposes 30 years with a deadly weapon finding, and reminds that parole eligibility requires serving at least half the term. In a separate case, probation is revoked for non-compliance, resulting in 8 months in state jail, with a blunt warning about addiction and accountability. Procedural items, lab reports, interview notes. Overall, the session balances strict decorum, realistic scheduling, and teachable moments from the bench. Clear expectations for counsel, defendants, and families alike.
Medellin, if you can recall that for Monday, the 28th, please. And I'll give you the docket sheet.
Thank you, Judge.
You're welcome. So your client is set for jury trial.
Yes, Your Honor. We just received some new evidence that I need to verify. We're not ready at this time. Just ask for a few weeks so that we can get people that we need under subpoena.
All right. And what new evidence is this? And is this related to a violation of a protective order or the unauthorized use of a vehicle?
The unauthorized use. I believe the violation of a protective order is no longer.
I still have the violation of protective order on the docket. It hasn't been indicted yet.
Motion down to when that you're finished with this.
Yes.
Essentially what happened, that one was dismissed by us back in October, but if it went to you or whomever, and the actual order, it didn't get signed.
All right. So it never came to me. I always sign everything that comes to me in my box if it's in order. Let me see.
I was going to ask if you needed me to print out another copy.
Yes. Because I don't, yeah, it's still pending. Everyone, just give me one moment. All right. While he's getting that dismissal for me. So on this, you can come back. On this case, what is the new information?
So Mr. Lira purchased insurance for this vehicle for the unauthorized use. I think that goes to his state of mind, believing that he legitimately purchased this vehicle, but I don't have the insurance agent yet. I need to get him under subpoena. He's not available this week to come in and test.
All right. So when he, I'm sorry if you got the slide over because state. So state, are you aware that he's saying he put insurance on the vehicle or something?
State was informed of this today, and the state hasn't been given a document, any confirmation of this. The state is interested, and it may push the state a certain way.
All right. Norma, put this for August 11th. Yeah. And then depending on what happens, you may be in trial August 12th.
Perfect. Thank you, Your Honor.
No, jury trial setting, but the trial would actually be on August 12th.
Thank you, Your Honor.
All right. Once you sign the reset form, you're excused.
Okay, thank you.
Thank you.
Good morning.
Good morning, Your Honor.
Good morning.
Good morning, yeah.
All right, the court is calling 2025 CR 002636 State versus Aaron Nathaniel Guillory. Can I have parties announced?
Megan Galloway for the state.
And Eric DeWalt, and I represent Mr. Gallery.
And are you Aaron Guillory?
Yes, Your Honor.
Counsel, have you received all discovery and did you review it with your client?
I did, evidenced by my signature on the.
Court will find that the state is in compliance with discovery. There are no applications.
Your Honor.
Mr. Guillory, did you review the true bill of indictment with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are waiving count 3. And then regarding counts 1 and 2, we would like to proceed on the lesser included offense of robbery, waiving the ag enhancement.
Oh, just one second. So count 1 will be robbery Just one moment. All right, let's do this way. So, count one
Proceed on the lesser included offense of robbery.
and count two,
Proceed on the lesser included offense of robbery.
count three.
Waive count three, Your Honor.
Any objection?
None, Your Honor.
Count four,
Proceed as is, Your Honor.
all right. Did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in counts 1, 2, you're charged with robbery? In counts 4, you're charged with unlawfully carrying a weapon with a felony conviction. Those offenses range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have pleas with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in each one of these in each one of these counts?
Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Guillory, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on counts 1, 2, and 4. They're asking that your punishment be assessed in each count at 6 years in the prison. There's a $2,000 fine and there are no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
It was, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to count 1 of the lesser included offense of robbery, how do you plead? Guilty, not guilty, or no contest?
No contest.
To count 2 to the lesser included offense of robbery, how do you plead? Guilty, not guilty, or no contest?
No contest.
To unlawfully carrying a weapon with a felony conviction, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State Office states 1 in attachments.
Your Honor, we've had an opportunity to go over that in its entirety. No objections to the admittance.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. And the court will find you guilty of count 1, guilty of count 2, guilty of count 4. Are you proceeding with sentencing?
Please, Your Honor.
Anything you wish to say on behalf of your client?
Not at this time, Your Honor.
All right, and you believe your client is competent?
I do, Your Honor.
Mr. Guillory, how far did you go in school?
And grade.
Why did you drop out of school?
Thank you, Your Honor.
I didn't drop out. They said I wasn't available to go to any SAISD schools anymore.
Why did they say you weren't unavailable?
From getting in trouble a lot at school.
Doing what? What do you mean by getting in?
Just misbehaving.
What do you mean by misbehaving?
Not doing what I'm supposed to do in class. Misbehaving.
So where are your parents?
They're in the courtroom.
In the courtroom.
Mother's in the courtroom and grandfather's in the courtroom.
All right. So why do you keep doing these things?
It's just not a mistake at all. It's I know what I'm doing. Just not doing the right thing. I want to fit in, and that's not the right thing to do.
Well, let me just ask you this, because it's obvious the people you are with don't care about you.
Yes, ma'am.
Because if they did, they wouldn't have involved you in this.
Yes, ma'am.
Do you even know why this person felt that the complainant owed him his motorbike?
I don't, not at all.
So, I mean, if you don't start making better decisions, you'll end up in prison for the rest of your life.
Yes, ma'am.
Is that what you want to do?
No, ma'am.
So why don't you just be around people who care for you?
That's what I'm doing. If I get a chance to go back home, work and stay around my family and do what I got to do to be successful in life.
All right. You want to call his mom up? Because I want to see what's going on with him.
You're back in.
Hello. I'm doing okay. How are you doing?
Good, man. I'm doing all right.
All right. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right. Can you lower your hand? If you'll state your name for the record.
Barbara Bates Hillary.
All right. So can you tell me, what is his issue? Why didn't he finish school?
Well, first of all, I adopted him. That's my great nephew. I adopted him. He was a drug baby. His mom was on cocaine and all. After I adopted him and stuff, and he finally came my father having convulsions, all of that. And then he went to school, being with the wrong crowd to me. Because as far as upbringing, he was raised right. So
you're saying that he was a drug baby. Are you saying that his mom used drugs while she was carrying him? All right.
yes, ma'am.
And then was he born addicted to drugs?
Yes. So I went through a lot with that because he was screaming and
Having withdrawals from the drugs?
Mm-hmm. Yes, ma'am.
Okay. And so were you the person who was called to take him home from the hospital?
Yes, ma'am.
And then he went through the foster care system with you?
Yes, ma'am.
And his mother, you adopted him?
Mm-hmm. Yes, ma'am.
And you're his great...
I'm his great aunt. I'm his mother's aunt.
Okay.
Mm-hmm. Yes, ma'am.
And where's the grandmother, his grandmother? Do you know?
She's dead.
Okay.
She's dead.
All right. All right. Thank you so much for telling me some things about him.
Thank you.
All right. Thanks. All right. So we are back on the record. And so the state has amended their offer to a cap of 6 years in the prison. Is that correct, counsel?
It is, Your Honor.
All right. So what I can tell both parties is I have worked on the CPS side before, and children who are born addicted to drugs. And this is why I tell parents, when you're using drugs and you're carrying a child, it's just like that child is using drugs. And when children are born addicted to meth, addicted to heroin, and all of that, they have withdrawals. And the only difference between their withdrawals and an adult's withdrawals, they don't know why they're in pain. And those babies, and everybody should get a chance to go to the hospital and volunteer, because those babies just scream incessantly and they're in pain, and there's no amount of rocking that you can do to stop them from screaming, because they're born addicted to drugs, they're having withdrawals, and then they want drugs, but they don't know what they want. And giving them milk, rocking them, doing the skin to skin contact does not soothe them, because they want drugs. So with regard to your client, I now understand why there were issues with him and why he was not allowed to return to school at 9th grade, because he was born addicted to drugs, and nobody knows. They have sort of an idea of what the drugs will do to your brain, but not really. So nobody knows what that will do to your brain. So the state has agreed to do a cap of 6 years. And what I can tell you from reading the police report, it appears that the co-defendant is saying that someone owes him money or owes him something. And instead of calling the police, this co-defendant goes out to take that person's motorcycle, which that person didn't end up with the motorcycle. And he brings your client along to get this motorcycle.
You read it correctly, the way I saw it.
So do you want to argue with regards to the cap of 6?
I would, Your Honor. May I?
Yes.
May it please the court. In speaking with my client and speaking with his grandfather and his mother, I know that in the fact pattern, Mr. Guillory was a follower, a hanger-on, and he was with other individuals and found himself in a situation as either an accomplice or really not what's going on. He understands the severity of his actions, but we were wondering if you would possibly do a downward departure from the 6 years. I know Mr. Guillory has been a cooperative individual with me. He's been able to go over the fact pattern with me and go over all the stipulations. So at this time, we'd ask if the court would have a downward departure in any way. It would greatly be appreciated.
All right. This is what the court is going to do. As previously stated, the court is finding you guilty as count 1, counts 2, and counts 4. And each count, the court will sentence you to 3 years in the prison, give you credit for any time served. The counts will run concurrently. There's a $2,000 fine. Time and money will run concurrently. And there is to be no contact with Samuel Farias, Farias. Is there anything else with regards to sentencing?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So let me explain something to you. Any action that you're getting ready to take that somebody wants you to participate in, before you participate in it, call your great aunt who adopted you and tell her, this is what they're saying. Do you think I should go along with this? Because people will involve people in things because sometimes the world is not a nice place. People don't care about your upbringing or what has happened to you. They will involve you in whatever they're trying to do. We can go off the record. I've had cases before as a defense attorney and as a prosecutor. You know what ends up happening? They used to call them SAPs, right? We'll let you go in and get the money. We'll let you go in and do this. And then they just sit and wait for you to come out. And if you get arrested, oh, well, they leave you. And then you're stuck with all the charges. Do you understand?
Yes, sir.
So you had better recognize who loves you, who's there for you. And if you have a question on whether what, well, not even if you have a question, any decisions you make, call your great aunt. You understand?
Yes, sir.
All right. Good luck to you.
Your Honor, may we be excused?
Yes.
Thank you for all your consideration.
You're welcome. Good morning. Court is calling 2021 CR 4510 State versus Ruby Benton Court. Can I have parties announced?
Megan Galloway for the state.
And are you Ruby Benton Court?
Yes, Your Honor.
Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it? And for the state?
Duffy Pitlock for the state of Texas, Your Honor.
Right.
Sila ko good for Miss Betancourt.
All right. And are you the same Ruby Benton Court who was placed on deferred adjudication in 2021 CR 4510 for the offense of credit debit card abuse on July 20th, 2021 for a period of 3 years? Is that you?
Sir.
All right, state.
Violation of condition number 5 in Bexar County, Texas, the defendant Ruby Benton Court did then and there fail to report to the supervision officer as directed for the months of February through September 2022 in violation of condition number 4.
How do you plead for that? True or not true?
True.
State. Are you waiving the remaining allegation?
State will waive and abandon the remaining violation. Thank you, Your
All
Honor.
right, no problem. Any objections?
Yeah.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Sir.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes.
Court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, there is, Your Honor. That is to grant the state's motion to revoke probationer, but to sentence under 1244 for 300 days Bexar County jail with a felony conviction.
Yes, sir. That's our understanding.
All right, what has she done on probation? Any objection to the court reviewing the court summary?
None from the state, Your Honor.
None from the defense.
All right, what I can do, I can tell y'all, I'm not inclined to grant a sentence under 1244. According to the court summary, she hasn't done anything. Have you done anything?
Have I?
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, did you report?
Yes, Your Honor.
Well, they say that you've been missing since February 2022. Did you report February of 2022?
I don't recall, Your Honor, honestly.
March, April, May, June, July, August, September,
I reported the first year.
and then you just stopped reporting.
I was under the assumption that it was only for a year, Your Honor.
No, you were not under that assumption. Let me tell you why you were not under that assumption. Because your probation was extended. So that means that you know that.
What do you? Okay.
So you haven't done anything.
Yeah, my understanding, she had a family situation. Her dad passed away.
Mhm.
And my understanding was during COVID.
All right, I'm not inclined to give you a 1244 because you haven't done anything. It says here, on the court summary, you didn't report for the months of February through September 2022, November through December 2022, January through March 2023. Field officers have made 11 field visits during this time. They made frequent contact with you, telling you you need to report. And they're like, your last report to probation was a virtual office visit in October. And they said it was an intervention urging you to report. And it says the probation officer has responded with phone calls and texts. And their last time they made a phone call was February 2023, and the recording stated that the phone number was out of service. Did you do any community service hours?
No, Your Honor.
Did you complete the theft course?
I registered for it. He was supposed to tell me where to go, but he didn't.
All right, so she hasn't done anything. So I don't think she's appropriate for a 1244. All right, the court is going to grant the motion, find you guilty, revoke, and the court will sentence you to 12 months in the state jail facility. Give you credit for any time served. Did you review the trial court certification of defendant's rights to appeal with your attorney?
Yes.
And did you sign it?
Yes, sir.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Sir.
All right, good luck to you. When you're released from, I'm sorry, I'm going to add the therapeutic community because I know there's a drug issue as well. All right, thank you. Hello. All right, the court is calling Cassandra Oberlinder. Can I have the parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Roberto Ambrosino for the defense.
And are you Miss Oberlinder? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Oberlinder, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading? I'm sorry, did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, we are not, Your Honor. We are proceeding for the lesser included attempted burglary of building to make this a Class A misdemeanor.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, the state is proceeding on the lesser included offense of attempted burglary of a building as a Class A misdemeanor. The range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail, and up to a $10,000 fine. Did you understand?
Yeah.
I'm sorry, up to a $4,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Oberlander, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of attempted burglary of a building. State recommends deferred adjudication. There's to be restitution to, how do you pronounce this? Adi or Adi?
Ida.
Ida, Aide, Gregoria Ramos. And there's to be no contact with the same in the MRT. Do you understand that to be your plea?
Yes, ma'am.
Defense is at the plea.
It is, Your Honor, but could we briefly go off the record on a issue that has been brought to my attention by probation?
Probation has already given it to me. I'll address that at the appropriate time.
Okay, thank
All
you.
right, thank
And that is our agreement.
All right.
Also the state's recognition of the agreement.
All right. Did you review the waiver of appeal with your attorney? Did you understand it?
Yes.
And did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
There have none.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 100 hours community service restitution, and no contact with the complaining witness. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Not.
State any evidence.
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
No objection.
State, you may be excused.
Judge.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt. When will you be back in Colorado?
Tonight.
All right, so we're going to reschedule this for sentencing, and the sentencing, if there's no objection, will be done by Zoom.
No objection.
No objection.
All right, Ms. Ferguson, recall this for sentencing on July 24th. It'll be by Zoom. Is there anything else?
No, Your Honor.
All right, thank you. And Ms. Abrams.
On the other three cases,
So who's on? Yes. All right, so what is happening?
Judge, we've conferred, we've been negotiating with the state on how to resolve everything with a possible package deal.
Mhm.
Our client's asking for some time to consider taking what could be a package deal if we don't resolve it. I don't anticipate a contested MTR, but the client's asking if he can come back. I believe he asked for 30 days to consider. I understand it's an MTR. I told him that I would ask for as much time as possible that he would permit.
All right, we will call you back on July 24th. That's on Thursday.
July 24th.
Yes.
Do we need a reset form?
No, because he's going to remain in custody, correct?
Right.
All right, Ms. Ferguson, on this case, it's being recalled for July 24th.
Let's see the form.
Withdrawn.
Applications?
There is one in there, Your Honor. There should be.
All right, and it's only for one case?
That's correct.
Court is calling 2023 CR 10854 State versus Bradley Galan. Can I have parties announce?
Galloway for the state.
Mario Moreno for the defendant.
And are you Mr. Gallon?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gallon, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
All right, you're charged with taking certain wildlife without the consent of the owner of the land. That is a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am, I do believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at $1,000 fine. The state is recommending deferred adjudication. They're taking in consideration 2024 CR 0339. There's to be restitution of $60 to Bexar County Laboratory and cause number 2024 CR 0339. There's to be a TAP evaluation and follow all recommendations. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea? State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your, thank you, you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for 3 years and there be 120 hours of community service restitution and a TAP evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
No objections, Your Honor.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
All right. If you're drug tested today, what are the results going to be? All right. So why do you keep shooting arrows onto a neighbor's property when they've told you they don't want that?
To be honest, Judge, it wasn't my arrows, but I'll take responsibility for that.
Well, I mean, you don't have to take the responsibilities. If you're saying that you're not the person who killed the deer on their property after they've been complaining about arrows being shot on their property, then you can always go for a jury trial.
No, ma'am, that's a different situation, but no, ma'am. Yeah, it was a target that was like on the fence line.
Was it your target?
Yes, ma'am. It was on my property. If it went past the target, if we missed it, and it would end up in their field.
How many times do they have to tell you to stop shooting arrows on their property? Why don't you put that target on your house and shoot it towards your own house? Then if you miss, guess what? You'll hit your house.
Yes, ma'am.
So they complain about that, and they complain about people coming on their property to kill deer. That's what we're here for. We're here for you going on property that was not your own, shooting a deer. The warden comes out, finds 2 deers with their heads removed, right?
Yes, ma'am.
And they've been shot by arrows.
Yes, ma'am.
And they're saying that's you. And from reading the stipulation, there's sufficient evidence, and that sufficient evidence is beyond a reasonable doubt that it was you.
Yes, ma'am.
So why are you going on property that is not your own to kill deer?
You're on the wrong crowd.
How old are you?
I'm 38.
You're 38 and you say you're running with the wrong crowd?
Yes, ma'am.
All righty. This is what, are you employed?
Yes, ma'am.
What do you do?
I'm a mechanic.
Is this your own business or somebody else's business?
That's mine.
All right. Court is going to sentence you to $1,000 fine. Taking consideration 2024 CR 0339. There should be restitution of $60 to Bexar County for laboratory testing, and that's the drug case. Do you have any children?
No.
What are their ages?
16. One son.
All right. Does he live with you?
No, ma'am.
All right. 3 years deferred adjudication. There's 120 hours of community service restitution, regular reporting by Zoom in person, regular random UAs, and probation. Do they have where he can do community service hours at the animal shelter? Yes. All right. The community service hours are to be performed at an animal shelter. And make sure they have cameras. Proof of employment within 30 days. No employment as a home healthcare provider or with minors. TAP evaluation plus follow recommendations. TAP evaluation is to be in custody. Probation, is there anything else? Okay. Field visits 1 time per month until further notice. Is there anything else you need from the court?
Ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you.
Your Honor, going into custody, I'm sorry.
Yes.
If I may, Your Honor, is it necessary for him to be taken into custody for the TAP eval?
Yes.
If he's testing clean?
Yes, he's going to be taken into custody for the TAP evaluation. All right, so he's scheduled for jury trial today.
Yes, Your Honor. We have a big paperwork here.
Okay.
Work it out.
All right, well, once the paperwork is done, I'll take that up. I'm going to have you all come back at has it already been?
It's been turned in. I don't know if it's.
Oh, it just needs to be, just needs to be sworn?
Yes.
That's what it is.
Yeah, it's working.
Okay, I'll take the plea up then.
That's great. Thank you.
All right, and Ms. Cruz, just have a seat, sir. Ms. Cruz, you're here on Charles Mullinex?
Yes, Your Honor. He was a no-show this
I'm
morning.
so sorry, I can't hear you. There may be
Yes.
something wrong with the audio here.
Can you hear me, Judge?
I'm going to respond to you by chat because there's something wrong with our audio. It's not you. Charles Mullinex. Deputy Laura, is that on off? Because we can't get the audio from her. Is it because of this screen?
Are they on the computer?
All right, she's on her phone. Victoria, could you try again with your sound?
Yes, ma'am. Can you hear me, Your Honor?
Yeah, no, that's okay. Could I see the file on Mullinex, please? All right, the court is calling 2025 CR 00524, 2025 CR 00525, 2025 CR 00256, State versus Charles Lewis Mullinex for the state.
Duffy Pitlock for the state of Texas, Your Honor.
All right, and defense counsel is by Zoom. Any objections to defense appearing by Zoom?
No objection from the state, Your Honor.
All right, the court is unable to get audio from defense's side. The defense has informed the court that they do not have contact with Mr. Mullinex, but they do have contact with his mother, and they do not know where Mr. Mullinex is currently located. This hearing was scheduled at 9 a.m. It is now 11:58 a.m. The defendant has not answered docket. Deputy Laura, could you see if I'll make the announcement for Charles Lewis Mullinex, please. All right, thank you. The defendant did not answer. The court will issue a judge's warrant. Any objection from the state?
No, Your Honor.
All right, the court will issue a judge's warrant. Defense counsel is aware that the court is issuing a judge's warrant and each cause number. Thank you, Victoria.
Yes, ma'am. You still can't hear me,
The court will
right?
remand the defendant without bond.
Okay.
Victoria, do you have anyone else with us?
No, Your Honor. May I be excused?
Yes, you may be excused.
Did you hear me?
Wow. Thank you.
Okay. Thanks. Bye.
Who knew I could do that? All right, and he also has a VR report. Could I see that VR, please? Mullinex. Yes, if I can have it back, please. Yes. Thank you. And then after this, we are taking our recess.
If this courtroom recap gave you a clearer picture of how justice works day to day, be sure to like this video, subscribe to the channel, and turn on notifications so you won't miss
Yeah,
the
I'm
next
only taking
update.
one.
In the comments,
Everybody
tell
else
us
is
what
gonna
stood
have to
out
come
most to
back
you
after we
today.
take our
Was it the
break.
sentencing in the murder case, the probation violation warning, or the judge's
It's
advice
supposed
about
to be
discipline and
the
family?
case
Share your thoughts
for
and let us know
Mr.
your
Dela Cruz.
questions. We'll
That's the
cover
one
them
where
in
someone
upcoming
is being
videos.
sworn in. Am
And
I
remember,
correct?
this is for educational purposes only, not legal advice. Always consult an attorney for
All right, so
personal
everyone,
cases.
come back at break. I'll see y'all back at 1:30. No problem.
Judge,
Yes.
I'm feeling a bit sick, maybe running fever. Can I appear on Zoom? We already did the plea. We
Yes,
just
you
need
can
to
appear by
discuss
Zoom.
something. Yep.
Yes.
Thank you, Judge.
You're welcome. But your client will need to be here.
My client's got to do.
Okay.
I just want to get close to it. I mean, I know.
Okay.